And each side will have 15 minutes, and the appellant may reserve up to 5. And we're ready to proceed if you like.
Proceed, Your Honor?
Yes, please.
Thank you very much. Good morning, Your Honors. Please record, my name is Jeff James, and I was appointed to represent Alexis Martin in this case. I'm not sure that it'll be necessary, but we'll just reserve 2 minutes for rebuttal in case there's some comment that needs to be made. This is a tragic case. I don't think anybody who can read the statement of facts and understand the background of this case cannot deny that this is a very tragic case. This is a case involving a life that we would just not have anticipated for a young woman to have gone to and to have experienced. It appears that everything in her life was disrupted to the point that she, at about the age of 11 to 12, was the victim of human trafficking. She, at that point, was taken into control of the victim in the case. She was served in a position of both a prostitute, running money, organizing and enlisting other young women to be involved in this prostitution scheme, and it all led to the point that at one point she had a boyfriend, and it was supposed to be a simple robbery, if there is such a thing, but unfortunately that went awry, and one of the males that was involved in the robbery ultimately ended up shooting the victim, who was, of course, the perpetrator of human trafficking, and the other person who was the victim in the case was shot in the head, and he did not die, but was seriously injured. This case involves really the court's interpretation of Ohio Revised Code 2152.021, which, to my knowledge at this point, is probably a case of first impression in the state of Ohio. I won't deny that from the onset, to some degree, and after reviewing the statute in this court, this issue being raised to me, and the court saying, we think this is important enough that someone should be appointed to represent her on appeal and raise this issue. And upon initially reviewing the statute, there appears to be no question that it deals with, or it provides for a discretionary, or so it seems from the plain language of the statute, that this is a discretionary function of the court, meaning when it has a victim that is a victim of human trafficking, I may at that point, the juvenile court may at that point decide to follow or impose the requirements of 2152.021, and at that point determine whether this child is amenable to any sort of rehabilitation. And in essence, what this really is a amenability or a diversion program that the legislature felt was necessary to enact, particularly when you were dealing with victims of human trafficking, juvenile victims of human trafficking. The concern I have in this case, and I think that was raised was not raised in the juvenile court, because I don't think anyone at the time of the proceedings in the juvenile court, and everything in the record seems to be clear, that at that point no one was aware, including the court, the prosecution, the defense attorney, of the requirements or of even the existence of 2152.021. The issue was never raised in the juvenile court. As a result, Alexis Martin was bound over. Only after the bind over to Judge Parker's court was the issue raised that, wait a second, this should have been addressed by the juvenile court. It was not addressed by the juvenile court. We're asking you to, at this point, to send the case back to the juvenile court, basically void the bind over, send it back for consideration. And Judge Parker, in looking at that and looking at the statute, ultimately issued a ruling saying that he does not think that is appropriate and refused to send this back, void the bind over and send this back.
Why isn't a forfeiture analysis appropriate where counsel for the appellant did not raise the issue before the juvenile court? Why aren't we looking at this from the standpoint of forfeiture?
In which case, really, are you saying a forfeiture versus a plain error argument?
Correct.
I mean, the idea that you did not raise this and therefore you just forfeited any entitlement that you may have to the application of 2152.021? Because I don't see anywhere in there where it says that that is something that is incumbent upon the defense or the appellant to raise. It seems to be more a direction to the juvenile court. I would think that the juvenile court is is in a position to understand this is the controlling, this is not a controlling statute, this is a statute, all right, which applies to juvenile proceedings, and you have some duty to address that. So that leads it more to a plain error argument more than a forfeiture argument in my view. And I think what you have to understand is the point of Court of Appeals or any appellate court, and of course the Ohio Supreme Court, is to give purpose to what the legislature has enacted. That is always your goal, to give purpose to what they have enacted. They have enacted this statute to specifically address a victim of human trafficking. And we have to look at what is the overriding purpose, and if we of course do that, we can just go to the definitions of Title 21.
Before we do that, if we could move back to the plain error analysis. The court in its order in numbered paragraph 6 toward the end indicated that the court does not believe that the juvenile can be adequately rehabilitated within the juvenile justice system. Does our plain error analysis have to end there? Because quite frankly, when that statement is made, the issue is addressed, is it not? Has been addressed by the trial court.
I guess the question is that you're asking, was it addressed? You could interpret that the court addressed that if the court considered it. If the court didn't even consider it,
You're right, the paragraph goes on to further explain why it is that the court does not believe, so.
And understand, because we're looking at a very heinous crime. And that is, of course, a concern that we have in a question like this, and I'm sure the state is going to raise in their argument, wait a second, are you talking about the fact that, in a case of a robbery and a murder, that we're going to look at some sort of diversion, amenability program? Is this person, possible to be rehabilitated? I guess, though, the more important thing that we have to understand is that what is the overriding purpose of the juvenile court? What is the overriding purpose of the juvenile court? Rehabilitation, not punishment. That's by definition. That is its goal. All right? And here we have a tragic young woman who has been controlled her entire life. From age 11, has been in this position of servitude and basically a prostitution, all right, who is engaged in a robbery and ultimately, indirectly, the murder of her perpetrator, of the person that enslaved her, the person that kept her in this lifestyle. And I understand that. I guess the question is that maybe the court would not have found that she was amenable to rehabilitation in this short period of time, this short time frame that is provided by 21-5202. That's correct. But would we not have learned a lot more about Alexis and what her situation was? Would we not have a little bit better understanding of what this young woman went through and what led to this circumstance? And should we, with that knowledge, all right, would we have not had that knowledge because you would have had the appointment of an attorney, a guardian ad litem, all right, to be involved with her for at least a 6-month period of time, all right? And understand, there were certain positives, all right, at the time that she was in the juvenile court system, that she had demonstrated certain positives. Why the psychiatrist in psychodiagnostic came back and said, no, they thought that, binding her over was appropriate. The guardian ad litem that was appointed to her for the brief period of time talked about some of the successes that Alexis had shown in the brief period of time that she was there. But if she had actually gone through this process and someone could have raised this issue, that do you understand that this is a young woman who is the victim of human trafficking, that at that point 21-52-021 does apply, maybe we should look at this and we could have a better understanding of exactly what went on in this young woman's life that led to these events, and is she possibly amenable to rehabilitation in the Department of Youth Services versus being bound over and tried as an adult?
But there's no question from the record that the court was aware that she was the victim.
There's no question that the court was aware that she was the victim.
The court said as much.
It did say so.
And presumably the court was aware that the victim of the murder was the person who was involved, who had involved her in it.
Correct.
And that's clear on the record.
There she was a victim of human trafficking and that the victim, or the victim in the case was the person. No one can deny that.
Sure.
The record is pretty clear on that.
Okay.
And I don't deny that I have an uphill battle, but I'm asking the court to consider it. I mean, what is the overriding purpose of the juvenile court system? What is the goal of the juvenile court system? And what is the application of 2152-021? The issue is that even if the court has discretion, right, does it not, I mean, what is an abuse of discretion? Abuse of discretion is when I totally ignore it. In this case, the court gave no consideration, didn't even address the fact that, well, wait a second, I am aware of this, I just do not believe that given the seriousness of the crime, that in this case, that the application of 2152-021 is appropriate. I don't have any consideration whatsoever. In fact, everything in the record seems to indicate the court was not even aware of the existence of 2152-021.
Is your reading of that statute, and the sections therein, that the court has discretion whether or not to appoint a guardian ad litem?
No, I think that's mandatory. If it has gone ahead and it has gone to the process of saying, we are going into, I determined that this is an appropriate case given the fact that we have a victim of human trafficking, that I am going to invoke 2152-021, I think the language is clear that it is, at that point, the court shall. Because there the court says, it says right there, the court shall promptly appoint a guardian ad litem for the child. That seems to be mandatory language. I think that's in 2152-021 F3. So the court would have had to appoint a guardian ad litem at that point. And of course, it would have gone through at least a 6-month process by which we would have had some input from this guardian ad litem as to what is the position of this young woman, what is the ability for her to be rehabilitated through the juvenile system versus being bound over and tried as an adult. I don't know. I really don't have much more to say about it. The thing that concerns me most, and I'm sure the state will have its position on that very much, is the fact that, we paint things with broad brushes, and I have a real problem with that. Because when we do paint things with broad brushes, we fail to actually look at what effect we're having, and we fail to understand the people and who they are, what their background is. Right? There's no question that there were involved in this case, the co-defendants, one who actually killed someone and shot another person in the head. There's no question that Alexis Martin was not present. She was not in the room when that occurred. Right? She did set up the robbery, which led to that. And of course, that was going to lead to the charge of murder because she was either complicitous or she was in the course of a felony murder. And that's what occurred in this case. I wish that the state would have made some different considerations for her, given the background. They chose not to. And it may be that we just go ahead and throw her away for 21 years plus. That's a concern for me, given what has happened to this young woman. This occurred when she was 15 years of age. And
You weren't even worried about
Yeah.
it. I'm gonna say that.
I probably won't have any purpose for rebuttal, so we'll turn it over to Mr. Casey. I'm sure that he will have a lot to say about the discretionary language of that statute.
Thank you.
Thank you.
May it please the court, I'm Richard Casey, representing the state of Ohio in this case. The defense counsel asks or states that we should know who they are. Well, according to the expert report, Alexis displays a repetitive and persistent pattern of behavior in which the basic rights of others are violated. She has a history of bullying others and engaging in physical altercations with others. She has carried a gun, taken things from others, and has been physically cruel to animals. Then she became the go-to girl for setting up home invasions. That's who she was. She was the victim of sex trafficking. Judge Teodosio knew it. She mentioned it during the hearing. She told the prosecutor, what consideration is that worth? The prosecutor said, it's a major consideration. And then Judge Teodosio puts it in her order.
But he
For-
doesn't refer her to the statute, he doesn't refer to the statute as to, if you are a victim of trafficking, what kind of guardian ad litem and so forth, 1, 2, I guess it is.
No, and now we're told that Judge Teodosia didn't have any idea that that statute existed. Where's that coming from?
Well, I think we're, not to speak for the appellant, but from reading the materials, seems like he's saying from the fact that she doesn't mention the statute and doesn't appoint a guardian ad litem.
She has to make the discretionary decision that she's going to use the statute. It is up to the person who's facing the court to ask for a remedy that the court can apply. In the state's opinion, it's not up to the court to say, well, do you want to ask for this, do you want to ask for that, or do you want to ask for that?
But if it's mandatory.
It is not mandatory, Your Honor.
Well, let me just ask the question.
Sure.
If the statute says the court shall appoint a guardian ad litem to make a report as to the best interest of the juvenile, how do you interpret that then?
I interpret that to mean if the court is going to apply the diversionary provision, then you appoint a guardian ad litem. Because the guardian, what the function of the guardian ad litem is, as the statute says, if the court decides to hold the complaint in abeyance, then the guardian ad litem makes recommendations as to the best interest of the child. That's what the guardian is there for. So I do not believe there, I think this whole argument boils down to Judge Teodosia sua sponte should have invoked the statute, a discretionary statute. I simply don't believe that's the case. It was not requested. Judge Teodosia knew about her history. She said, as plain as can be, that she knew about it, and she
Go ahead.
and she did not invoke a 270-day discretionary diversion program when she had the ability to keep this minor in the juvenile court system for 5 years. If she doesn't believe that 5 years is enough, why is she going to believe that 270 days is enough? Knowing her background, and with no request by the minor to go into diversion. But that's the argument now. Putting all of that aside, Judge Teodosia erred because she wasn't aware of the statute, and she didn't invoke it.
Well, we just talked about the fact that she asked the prosecutor, what does this mean?
And he said it's a major consideration.
But he doesn't say, well, it means that you can look at 2152.021 and make a discretionary call, Judge.
Correct, he did not say that. I 100% agree with you, Your Honor. He did not say, Judge, you can do this. When the minor's attorneys didn't say that either, they were standing there.
Oh, absolutely, neither party mentioned it.
Right. So, at the bottom, ultimately, the state's position here is, Judge Teodosia was aware she was a victim of sex trafficking at some point for some length of time, and from the report we know that the person who was ultimately murdered was the perpetrator of the trafficking. So Judge Teodosia knows all that. She knows how old she is. She hopefully, counsel will concede that Judge Teodosia knew that she could keep her in that system for 5 years, and she did not, of her own volition, say, wait a minute, I'm going to put her in a 270-day diversion program. So that's error? I don't think so.
Do you, go back and read your brief, but I'm not sure whether you specifically addressed this or not. Do you agree that the act charge is related to the child's victimization? Do you believe that the charge is related to the child's victimization?
the murders, the aggravated murders, no.
So you would interpret that narrowly and only be related, like if the juvenile would be picked up for prostitution?
I think it's a possibility. I don't think it's decisive in this case, but the acts charged were a home invasion planned by Alexis Martin to rob, and there's some, it's hard for me to answer because there was another appeal that involved this home invasion. But I think this record, you will see that she set this up to rob.
Well, we may or may not have to get to that portion of the statute to decide this appeal.
I agree with that, yeah.
But since this is pretty much an issue of first impression for this court, I was just wondering what's your opinion as to how narrowly or broadly we should interpret the act charges related to the child's victimization. Almost any crime could be related to the child's victimization, or you could interpret it to say if the specific crime is relating to the trafficking itself, such as prostitution.
Well, I think there's an argument either way. The statute, as I'm recalling or trying to recall it, I think talks primarily about sexually related offenses, prostitution, that type of thing. So that would, I think, lead to an interpretation in the latter part of your comment rather than the first. However, if the interpretation is going to be that, and I'm not saying this is wrong, if the juvenile court is there to rehabilitate and help victims of sex trafficking, then a broader interpretation is appropriate. I'm just saying, from the text of the statute, you can interpret it narrowly, and as counsel's pointed out, there's no case interpreting the statute that either of us are aware of. But I don't believe the acts that Alexis Martin were charged with had anything to do with human trafficking.
Thank you.
I probably used up all my time.
You have a little left if you want to.
I don't think I will.
Okay, all right, thanks so much.
Thank you.
You do have a minute and a half.
The only thing I'll point out for the court is to take into consideration, and I was in error, the court did not appoint the guardian ad litem to represent her in the proceedings. But there were both a psychologist who testified in the bind over, and there was a licensed social worker. And one of Mr. Webb, or Dr. Webb, concluded that Alexis was best suited for rehabilitation in a structured setting, mainly prison. He talked about the fact that since she had been in the system, the 8 to 9 months prior to the amenability period during which Martin had, and because she had experienced the longest period of environmental stability in her young life, and except for minor setbacks, had been adjusting okay to dealing with others in a normal fashion. The licensed independent social worker indicated that Alexis had excelled in achievement while in detention. She had earned numerous incentive-based coupons for good behavior and social interaction, helping others, as well as Martin's attainment of one of the highest levels of privileges in the detention in the system. Martin had, on her own initiative, sought out others in detention to foster and nurture. She had begun to write a self-examining journal and partake in Bible study. I'm just saying there were all these things that were the positives. And the only reason I want to bring that up is that when the state took the stand, they talked about her background and all of the bad things and all the bad character that she had exhibited in the period of time in her young life that she was the subject of human trafficking. And for the first time in her life, when she was actually put into a structured setting and provided with some guidance, everything seemed to indicate that she was responding well. And isn't that what we want? Thank you.
Thank you both for the arguments today, your presentations